A contract affected by illegality is one that fails for reasons external to the contract and the parties to it. Illegality as a topic covers a wide range of different areas. The effects of illegality upon a contract vary greatly from none at all to complete unenforceability. The principles governing illegality in English law are set out by Peter Gibson, Lord Justice, in Hall v. Woolston Hall Lager Limited from 2001. Illegality will affect all of the following contracts: a contract to commit a legal wrong, for example a murder or robbery, a contract which promotes immorality, a contract which is performed illegally, a contract which is not formed in accordance with the procedure prescribed by a statute. It may be helpful to consider certain distinctions that exist within the illegality cases. The first distinction exists between common law illegality, such as a contract to commit a murder or a robbery, and statutory illegality, such as a statute which requires the vendor of a certain good to possess a license to sell the good. A second distinction exists between contracts that are illegal as formed, such as the contract to commit a murder or robbery, and contracts which are legal as formed but illegal as performed, a contract to deliver pizzas, performed by a motorcyclist who has exceeded the speed limit, for instance. In general terms, courts will not enforce a contract which involves an illegality, nor will they allow the recovery of a benefit conferred by an illegal contract. Courts can, however, allow a party to enforce a contract or to recover a benefit conferred. The result is to create a certain inconsistency in cases involving illegality. In the case of Le Laboratoire Servier vs. Apotex from 2012, the court provided a useful summary of the approach to be taken in considering the principles of illegality. As seen above, contracts may be illegal as formed or illegal as performed. Where they are illegal as formed, the statute prohibits their creation. A court will not allow the recovery of damages under such a contract. Where an innocent party seeks some benefit from this contract, it may be allowed in some circumstances. Where a contract is illegal as performed, the court will seek to establish what was intended by the statute. Where a contract is illegal as formed, it is void ab initio, from the beginning. For example, statute may expressly prohibit a certain type of contract. See, for example, the cases of Ri Mahmoud from 1921 and Mohammed vs. Alaga from 2000. In such instances where the contract is void, the issue is whether or not a party who is innocent of wrongdoing can recover a benefit conferred by the contract. A contract may be legal in its formation, but illegal in its performance. See St. John Shipping Corporation vs. Joseph Frank from 1957, where Judge Devlin distinguished between contracts which were entered into for the purpose of committing an unlawful act, which were unenforceable, and contracts which were expressly or impliedly prohibited by statute. Common law illegality. Professor Treitel divides these situations into two categories. First are those cases involved in the commission of a legal wrong, the contract to commit a murder, for example. Second are those cases which involve contracts contrary to public policy. For examples of cases in the first category, see Alexander vs. Ryson from 1936 and Beresford vs. Royal Exchange Assurance from 1938. Courts have found that public policy is offended in such a way as to make the contract illegal in a number of different areas. Because there is no single form of illegality, it is very difficult to ascertain the effect of illegality upon any one contract. The outcome in the case law can be very different. This is not surprising given that the impropriety involved is very different in its seriousness. Before examining these different outcomes, it is worth bearing in mind that the contract may have both legal and illegal terms. Where it is possible to remove an illegal term or an illegal part of the term, the court can sever that term and leave the remainder of the contract standing. Although a court will not enforce an illegal contract, it may be able to provide an innocent party with a remedy in some other manner. See Strongman vs. Sincock from 1955. Another important point is whether a party can be permitted to recover a benefit conferred upon the other party to an illegal contract. The general rule is that courts will not permit recovery under an illegal contract. See Holman vs. Johnson from 1775. There are, however, many cases which illustrate methods by which recovery will be allowed.